Good morning, or good afternoon, and good evening. So today's video is going to be on the straw man. So we're going to be discussing the straw man and what is really the straw man. We have already discussed how law is fiction and how law does not actually apply to you, how it was later adapted in the late 1800s so that it applied to people. Remember that term people implies also states. We'll get into that in a second here. So I just wanted to give a legal notice. This is not legal advice. This does not give any of this does not give anybody permission to use me as an attorney in anything. If you wish for legal advice, ask a legal attorney, someone with knowledge and experience. This is for educational purposes only. Now that that's done, let's get this started because there's a lot of information here. We're going to discuss what the straw man is. Now, we understand that the straw man is a fictitious man that was created in 1933. What we don't understand is how it was created and why it was created. And nobody ever explains why it was created. Well, I'm going to explain today. So, in 1933, the governors established all the governors of every single state, that includes my state of California, met to discuss the emergency. So, remember, the term emergency can be construed to mean anything. It doesn't really clarify the terms emergency when they use executive orders and stuff like that. Remember, executive orders are unlawful. They exert the power of the Constitution from the people and to have open and unlawful debate. These should be declared void only in certain circumstances. They should limit the power of the executive order to a certain thing, and they should clarify what the president can and cannot declare a national emergency and specify. Remember, all laws should be written in plain English. They should not be written in such a complex language that only a few elite people understand them. So we understand in 1933 he created an emergency, declared. The governors are now at the meeting, okay? The government was in bankruptcy. Obviously, we went into bankruptcy. Remember, we went into bankruptcy multiple times. 1929, the 1929 crash, the 1933, we actually went bankrupt in 1988 and 2008. So the next one we're not going to be able to do with inflation. So this is key to know how to control the straw man, the real you, the natural man, me, and the straw man. So the bank is in bankruptcy. They can't fund the banks no more. This is actually how banks actually go and become territories. They go bankrupt. The bankroll is nothing. They run out of money. They have to go into debt. They have to sell off the infrastructures. Remember 12803 and the other one that I read 13. You have to go back to the video on that one. The executive order starting with the 1-3 that I listed on there and have there listed. Please look at that. These sold off our infrastructure, sold off everything. Also, our bonds were pledged off. Birth certificates are considered a pledge. They are considered an obligation. So, I highly recommend people to look up the 80th Congress session, Session 2, Chapter 645, June 5th, 1948. Now, this established obligations. It also establishes amnesty law and establishes terms such as facilities. These are important things to understand. Remember, all the things that I am teaching you is commercial law because we went into commercial law. We obligated all our laws over to commercial. There is no common law. You do not want to go into common law, especially if you know about the judicial canon laws. I'll do another video on that at a later time. and judges and how they can be held liable, how they should be held liable. We'll go into that a little bit later. Actually, on another video. And so the government made pledges to the United States of America Incorporated. Now, remember those United States of America Incorporated I showed you? Well, which United States Incorporated are they now giving money to? Right? Which one's now bankrupt and bankrolled? Remember, one hasn't paid its taxes since 1990. Others have not paid its taxes even farther back than that. The pledge was the assets, the people. Remember, if you look up the 80th Congress, Session 2, Chapter 645, June 5th, 1948, you will find that birth certificates, under certificates, includes all certificates, can be construed under the law as a pledge and obligation to the United States. Now, this was necessary to separate the straw man from the living man. You have to also remember that your birth certificate, that all the digits on that card, that does not belong to you. First off, look on the back of your card. It does not belong to you. It belongs to the Social Security Administration. Remember, you are the agent, the registered agent for that card holder. The principal, the owner is the Social Security card. It's the Social Security agency. Now, remember, these are legal fictions. These are not real people that are being created. These are being created from paper. And I'll explain here why. The fiction was to be subservient to the government. The real original Social Security was actually against, they were actually against having the government have all that information. They were actually originally against it. The government put pressure on them and forced them to do so. You remember GATT, the General Trade and Tariffs. So how are we? So you're asking, how are we commerce? Well, they registered the birth certificate, the security instrument. Remember, because it's an obligation of the United States under that code, 80 Congress Session 2, Chapter 645, June 25th, 1948. We were obligated. The governor's pledged they agreed to register the birth certificates of all the people of the U.S. With the U.S. Department of Commerce. The birth certificate is the security instrument, collateral, used to back the pledge. The legal fiction was created using the fiction. So they used that birth certificate, put you into U.S. commerce. Now you are commercialized, and they pledge you over as to God knows who, and those people hold due course in your state without you actually ever having knowledge. Now, these all capital letters were designed for legal fiction because the pledge you were determined into surety. Remember the definitions of surety. The legal fiction surety is one for responsible who pays. So, when the government or any corporation uses any process whatsoever against the legal fiction, so when you say, yeah, I'm going to show up in court, remember, you are becoming the surety. You are agreeing to the contracts of their term. You are saying, I agree to the terms that are restrictive to me, but give you all of the power. I'm using the district attorney as an example. And you are not separating your name from the legal fiction that is being created, because you are acting under the presumption of the straw man because you have not redeemed yourself through the redemption process. And when I mean redemption process, I am actually talking about security. So what it is we have to secure our property through the Universal Commercial Code, UCC 1 and UCC 3. Remember, your name now is under look this up, 15 USC 1127. The definitions include commercial name, trade name, jurisdictic name. These are very important terms. In this section, you will find government officers or employees function in commercial capacity after considerable research. The John Doe was created through the presumption of a government employee, which was the doctor. Now, you are now subject to levy and liens. Look up 26631. If any person liable to pay taxes neglects or refuses to pay within the 10 days after notice in demand, it shall be lawful for the secretary to collect such tax. Such further sums shall be sufficient to cover the expenses of levy. The levy upon property in right to property, except such property as exemption under section 6334. I don't have section 6334 here with me today, but I'll print that out, find it, and we'll do a video on that if people comment and they like this. Belonging to such persons or on the liens provided in this chapter for payment of such tax. Levies may be made upon an accruing salary or wage of any officer, employee, elected official of the United States District of Columbia or any agency of Columbia by serving notice of levy on the employer as such defined in 3401D, such officer, employee, or elected official, if secretary makes a finding that the collection of such tax is in jeopardy, notice in demand for immediate payment of such tax shall be made by the secretary, and fail upon refusal to pay such tax collection, therefore levy shall be lawful without regard to the 10-day period provided in this section. Now, I want to break that down because that was a lot of information. That was a lot of things I just said. My phone actually just clicked and took a picture of me. It doesn't really think I just noticed. But, so, they have the right to levy taxes within 10 days after the notice of demand, and shall be lawful for the secretary to collect such tax. That's if the person is liable to pay taxes. Now, under section any person may be payment belonging exempt. So I want to read this exemption part. So I think this is exemption section. I just looked it up. Exemption section 6334. Belonging to such person. 6331. It specifically states that levies may be accrued salary on wages, officers, employees, or elected officials of the United States. And you have to look this up in the Internal Revenue Code. This is section 6331. And it states that, seeing the sections of the state, levy may be made upon accruement of a wage of an officer. I'm not an officer. An employee. I'm not an employee. An elected official. Definitely not an elected official. Of the elected official of the United States. Definitely not an elected official of the United States. The District of Columbia. Definitely not in the District of Columbia. I'm in another state. I'm in the Union. So the question is that commercial instrument by which parent corporation, which U.S. federal government is it in? You have to remember they're transmitting What they're doing is transmitting utilities within a commercial scheme. Venue World, this is an entity. So that's when they ask you, what do you have on your person? Please specify. What do you mean what do I have on my person? Specify person, please. Because legally speaking, you have to remember, legally speaking, you have to make them specify what is person. Are you saying I'm an estate? Are you saying I am an individual? Are you saying I'm in a corporation? It doesn't matter, because if in my later videos, I'm going to show you how to get rid of these. I'll be making more in the future. I'll be showing you how to get rid of these bullshit laws that are being thrown up on us. But you have to remember, who's getting control of your straw man? Remember, the lawyer's acting as a trustee. The lawyer next to you is a trustee. You hired him, right? He's your employee. If you look up Corpus Juris Secundum, Volume 7, Section 2, 3, and 4, that's Corpus, C-O-R-P, Juris, J-U-R-I, Secundum, S-E-R-C-U-N-D-U-M, and Volume Sections 2, 3, and 4 talk about ward of the court, which is making you a minor under that Internal Revenue Code. Remember, 363.6 under the CFR code, you are a minor under the eyes of the law, and you are being transferred and transmitted into utility. So the ENSLEGIS, I apologize, a creator of law, an artificial being as contrasted by the natural person, applied to corporations, considered as derived by the existence entirely by law. Black Laws Dictionary, 4th edition, page 624. Definitions of transmitting utilities. Now, this is interesting. Transmitting utilities, meaning a person primarily engaged in the business of operating roads, subways, streetways, or trolley buses. So, California Highway Patrol is transmitting utilities. The Martinez Police Department is transmitting utilities. San Diego Police Department is transmitting utilities. San Francisco Police Department is transmitting utilities. Transmitting utilities means a person engaged in the business of operating a railroad, subway, street railroad, or trolley bus. B, it means transmitting electronic communications. So let's say they're taking and sending information out about you. That is an electronic communication that is being sent out by email, by radio communication, or by some other forms of means of communication. Transmitting good by pipeline or sewer, and transmitting or conducting electricity, steam, gas, or water. They're doing all the above. A person means a corporate fiction, something other than a human being. So, what happened was, around the time of the United States, the southern states of the American Union, the United States was busy putting their plan into the United States. This plan was necessary to the United States and would increase the jurisdiction of the United States. Remember that the Article 1, Section 18, Section 17 of the United States Constitution that talks about the jurisdiction, these gave them absolute power over everything, because the water miles go for miles, and they have control over all water lands. So, during the 1930s, remember, we went bankrupt. And at that time, the United States, we already talked about, became a debt, an owner of thing, a presumptive by accommodation. to owe a public debt. The United States, the logical thing of the United States was to discharge that debt from the trust fund. There is a way for the United States to get around paying public debts, is to claim that the owner cannot be the owner if he agrees to be an accommodating party for the debtor person. There it is. If the person is truly the principal, they would know how to handle their financial and political affairs unless they have never been taught. If the owner admits by his action out of ignorance he was the accommodating party that has taken the debtor's liability without the consideration in the exchange. Remember, an exchange is the individual who is exchanging one goods or trades for another, commodities. Here lies the fiction again on the debtor's liability without getting considered in the exchange. Here lies the fiction again. The owner of the thing does not have to agree to be the accommodating party for the person to be the debtor. He just has to act like he agrees. There is an easy choice of going to jail or debtor person. He's just going to act like he agrees. That is easy of choice of going to jail or signing for the debtor person, that the presumption that he can accommodating party is strong enough that the court can hold the owner liable for the taxing when he actually owns or owes. Debtors may have use of certain things that belong to the creditors. Remember, we're the creditors. Most of the money that is owed to us. Now, the quasi-user, the state, the property, the thing, has discovered who he is in relation to the state corporation, based upon the security agreements, which we'll get into later. The owner must notify the Secretary of State and that he's going to handle his own affairs, that he's going to do during the chargeback process. So there is a chargeback process. I will state that, yes, there is a standard for gold. I have recently found an article that JP Morgan is now accepting gold. I have talked with gold exchanges that have given me information regarding gold. Don't recommend gold bars. Recommend silver bars. Silver bullion, gold bullion coins in exchange. They're not being tracked or monitored. Remember, when you file a W-2 or W-4 and a 109, this directly holds you for taxes. You're directly being held for it. Remember, Senate Document 43 of the 73rd Congress, 1933, did declare that ownership of all property is in the state. The individual's so-called ownership is by virtue of government, i.e., law amounts to a mere user only. Remember, it can't be a right if you can take it away. The property is subordinate to the necessities of the United States government. Under House Joint Resolution 192, June 5th, 1933, Senate Report Number 93549, and Executive Order 6072, 6012, 6246, and Congress and President Roosevelt officially declared bankruptcy of the United States. Now, what breaks down, back in 1933, the bankruptcy could no longer pay their debt. The pledge was the American people because the government could no longer pay its debts and pledge the American people, I lost my spot, without the consent of assets to the government afloat. So they're just operating. The government no longer had any way to pay its debts with substance and bankrupt. It lost its sovereignty. Remember, the states are sovereign under that 10th Amendment. All states are sovereign, and they stand outside, separate from the Constitution. Remember, now the United States, which United States, is unconstitutional because it is now bankrupt and stands outside of the Constitution. Now, I want to hold on here a second. I apologize. Gotta find my. I know this sounds a lot foreign, but I'm going to break it down too. I'm not just gonna leave you. What? If you look at the term, so I want to go over the terms of some of the terms that I've said. Encyclopedia Judicia said 1972, cognate, a person or thing in its origin. The definition of trustee, somebody who is liable for a debt or presumption of debt. Hold on here a second. I'm looking for my other. Definition of debt. So in the 1920s, the state accelerated and pushed for the mothers and babies to require upon the new federal property, the so-called free black slaves, life was good and people were not paying attention to what was happening in the government. The stock market crashed. Those who were not inside were not warned to take their money out before they lost everything. In 1930, the legislation provided that registration of babies through applications of birth certificates or so-called government workers could get maternity leave with pay. The state pushed for registration, surrender of ownership. Remember, you're on a ship's bow, you're in martial law. If you understand and looked at the old Abraham Lincoln executive order, I believe it's number 1 or 2, you'll see that we were in martial law, and we never left martial law because he was executed before that ever happened, and we never left, and we were still in the military tribunal. So at this point in time, there actually is no laws with martial law. But that's not the point of what I'm trying to point out. The state pushed for registration and surrender of ownerships of cars and applications of certificates of title. That includes birth certificates. Remember that 80th Congress, second session, section 645, June 5th, 1948. And through the registration of lands, deeds of trust, which turned in the land over to states. Constructive trust was secretly created people and binding them to the United States democracy. Why do we have to pledge our allegiance to anything? If we're in a state, we're obviously a citizen of that state. It's a corporation. It's pledging our allegiance to a corporation, a fictitious entity. Please go back to my other video about the debt collecting and creditors, and you'll see that that it's a fictitious entity. Pardon me. And so the surety thereby agreeing to be sureties for the debts of the United States, and the president supplied the diversion to the people's attention of what the government was doing. The Social Security program was implemented along with the numerous programs that invited American people to volunteer sureties. Remember the sureties. I explained this in my last video. Please go back, look at it. You'll see that you'll see case law, everything that supports this. The plan was well on its path. 1933, massive registration, surrender of property through the United States agencies, including states, subdivisions were assured that the United States is and its officers would get rich beyond their wildest dreams if all this was done without full disclosure of all the material facts and accompanied with the application of registration. Remember, we discussed this. A contract without full disclosure is not a lawful contract. This is unlawful. If remedy was available to the people and the people chose not to choose remedy, because remember that there's remedy, we can discharge that debt and get it down to zero. That's the duty of the trustee, the state, the employee. All that is done without... If a remedy, the United States only needs to provide the remedy. It was not required to explain or even tell the people where the remedy could be found. The attorneys, the remedies are found in your UCC 2 and UCC 3 and UCC 9. You also can find it under the CFR. You can also find it under the Consumer Protections. And financial credit protection people, you can find under 661 and 667, you can find some of your rights there. And I believe it's 616 that gave them probable cause to be found. The attorneys don't even have to... attorneys did not even have to be taught about the remedy. These gave them probable deniability. When the people struggled to understand the new laws, the legislators did not have the intricate details of law explained to them regarding the bills that were passed. They never do, right? The commercial code is merely... let me start here. With probable deniability, even when the people knew they had remedy and pursued it, the judges, attorneys, and legislators would act like they don't understand your claim. That's what they usually do, right? Requiring public schools and teaching civics, government classes out of approved political correct textbooks. They teach you only agendas what they want you to teach. They never teach you about all these things. But in 1933, they put an insurance policy in place with the House Joint Resolution 192 that we discussed, and it promulgated federal registry. The executive order issued on April 5th, 1933 paved the way for withdrawal in gold. I'll do a video on that very shortly. The United States Representative T. McFadden was filed formal charges on May 23rd, 1933 against the Board of Governors of the federal banking system and the control of the currency and Secretary of State of Treasury. Congressional record, May 23rd, 1933, pages 4055 through 4058. HJR passed on 1933. The bill removed the requirements that the United States should subject employees to be paid with debts in gold. It actually prohibits the inclusion in clause of gold and contracts that would require also cancel every contract clause. It would require obligations to be paid in gold retroactively. It provides that the United States are subject and cannot use any coin or currency to discharge a public debt as long as it was a normal course of business in the United States for a time. United States notes were currency and used in discharge of debt, but later the Federal Reserve provided a new medium of exchange through the debt instrument. Remember, we discussed this. I've shown this through a video already, that the Treasury Department does not have legal tender. They have stated this in their own words, in their own words and own record. It is used to discharge debt. So remember, it's a debt dollar. You can't discharge a debt with debt. in 1950, unless they want to take on your other debt. In 1950, the Uniform Commercial Code was presented to the states as a means of unifying the general acceptance of procedures for handling a new legal system with the dealing of commercial transactions. The fictions, as they thought, were real security instruments, commercial paper contracts, debt instruments with collateral accommodating parties, used instead of money of exchange. The money was disappearing. New money was created. Money of account, bill of exchange, and a uniform system of laws have been put in place, allowing commercial venue, the courts, to uphold security instruments that depended on the commercial financial and basis for compelling of a performance. See tender payment in your state statute. I've showed you my state, California Constitution, Article 2, that talks about the tender of payment. All of it was accomplished in the 1960s. In 1964, most states have adopted the Uniform Commercial Code. The Commercial Code was a mere codification of accepting and requiring procedures of engaging commercial activities must follow. So, when you walk into a court, you are now, remember, on a bow of a ship. You are now acting in a commercial fashion. Your name is being used commercially. Remember, you already are going into court. You're having a proceeding with an unrebutted reception because you didn't even know about it. You weren't even served. You were probably arrested and not be able to even file a rebuttal or a rebuttal of the presumption of what they have. You probably pleaded guilty when you should have asked for more time and for them to supply you with evidence of any conclusive proof that they may have that may show that you have that they have anything on you. You have the right to do so. We discussed already that under the 1272 and 73, they must have a letter of acceptance, they must have an oath of office, and they must have a bond. But the security instruments were placed as collateral debt in exchange of accommodating parties. They could be used instead of money. Money of exchange, money was disappearing. New money was being created. Money of account. The commercial is a merely codification of all procedures of people engaging in activities must follow. The basic principles had settled for thousands of years ago, refining its sophistication over the years in the 1900s. The age-old principle of commerce shifted from substance to form. Presumption became a big part of law. Without a degree of force of presumption, the direction and the force criminal claims could not be supported in their court. If claimants were required to produce their claims every time they collect money from the people, they would seldom be successful. The people expressed that the codes combined with the meaning of dealing with substance commercial activities, meaning the dealing of presumption of commercial activities, the principle working for the people as they do for the deceivers who rule not the respective person. Now, so that's saying that they made the laws so that it could be settled the claims, but it would be hard for them if they were required to produce their claims every time. It would be hard and nearly impossible for them to create substantial commercial activity, and the presumption of evidence could be rebutted. But those who were enticed for the people to register their property, land, guns, cars, children into subdivision states. Remember, when I mean subdivision states, what United States are you registering your gun in? What state of California are you registering your gun in? The definition of property is the interest one has in a thing. The thing is the principal. The property is the interest. The profit is made from the property along with the owner of the thing. profits were made by the deceiver who pledged the bond, the bond that's going to be put in your name, the commercial profit, but the profit does not belong to the deceiver. The profit belongs to the owner, you, me, of the thing. Remember, the owner of the thing is you. The substance cannot appear in fiction. Watch the movie Last Action Hero. You'll get a if you watch it and listen closely, you'll understand it a lot more. It is impossible. Sometimes fiction made look. Sometimes the fiction is made to look very much like substance, but fiction can never be substance. It's impossible. The profits from the registered are put in a constructive trust for the benefit of the owner. Remember, we are taking you into custody. Look up the term custody. In your state, look up the term custody, what it means legally. And we are holding you now under the care of the custodian, terms you need to know, of the sheriff's department. Well, by what authority? How can you hold me with another trustee? I'm a man. I'm a natural living man. I'm not property. I can't be held. Because they create a constructive trust for the benefits of the owners. Remember, the owner is not just you. The owner is also the holder in due course. The scheme represents fraud. Remember, a court cannot proceed forward if it commits fraud. Now, if the United States has a goal, the United States can pay the bill from the trust account, the fund, or a financial ledger. The definition of fund is money set aside to pay a debt. There is a fund to discharge the public debt attributed to the subject. But ultimately, the accommodating party, the American people, us, the national debt is who the money is owed to. And now you understand how we are registered. You understand how we are registered as commercial entities. We are registered through the laws of 1933. You have to remember what is an endorsement. I endorse and create something with my signature. Your signature has a lot of power. You do not have to sign a banknote. Remember, because it is a banknote. These banks are in default. These courts are in default. And they must issue a negotiable instrument, a draft, a public offering. That's all the complaint is a public offering, a complaint, a draft, and you openly accept the draft, saying, yeah, I plead guilty, or no, I don't plead guilty, not knowing what you're actually saying. What you're really saying is, well, I'm the biggest sucker in the world, and you're going to put my ass in jail and take everything, and there's not a damn fucking thing I can do about it. I recommend for anybody who is watching this to look up the Silent Weapons for the Quiet War Research Technical Manual SW790S.1, which discloses a declaration of war upon the American people. It's a manual with an analytic declaration of intent. I also recommend reading page 3 as well as page 7 of that manual. Of this, and as well as page 8. This stuff will blow your mind. please remember that when your mom signed the signature, it should have been your dad signing the signature because your dad's the executor. Give me a second. Let me try to find my notes here. I'm going to pause this video for a second. And we're back. In 1913, the United States, remember in 1913, the United States added private laws. So there's not just public laws, there's private laws and public laws. For most people who do not know that. Most people who are now just watching this are realizing, well, if I can't be taxed and I'm not subject to tax, how am I being held liable? Well, in 1913, they created these private laws and subjected us to the so-called free slaves from the Civil War. We discussed that and how the King of England duped us and we're still English citizens. So after that, in 1870, they created the 15th Amendment, which subjected citizens to apply for marriage, registry, a birth certificate, death certificates, requiring was all an application. Benefits came with new citizenships, but with these benefits came duties and responsibilities and liabilities. They total regulated by the Registry for the District of Columbia. Edward Manhouse is attributed to the very detailed plans to impetulated to enslave the American people. That's IMPLEMPENTED. If anybody can pronounce that, if I'm pronouncing that wrong, I apologize. The 13th Amendment in 1865 opened the way for for us to voluntarily open for slavery. It was not really clear what had been implemented. The Central Banking Industry and the Federal Reserve Act in 1913 was the ability to decrease and circulate currency and tax and legislate through the 16th Amendment in 1913. Support for the presumption of the American people had volunteered in the position of the United States democracy in 17th Amendment in 1913. The passing was provided by the courts by the British Crown in creation with the American Bar Association in 1913, right? We talked about the registry of the children. Give me a second. I'm going to pause this video. Remember that the banks in 1871. In 1868, to establish an underlying debt of the government. It said, in times of war, laws are silent. Cicero. Executive orders under the law of the war of powers, emergency laws under the law of necessity, meaning no law whatsoever as per maxim law, as necessity of no laws. The laws of forbidding killing is void when done in self-defense. In times of war, laws are silent. Remember, we're always in a time of war because we never, ever left. Because Abraham Lincoln, through Executive Order 2 in April 1861, filed an executive order declaring a national emergency, and since then, because he was shot in the head, there has been no de jure sanctioned by law in Congress. There has been no lawful de jure Congress since 1861. The executive order brought the law of necessity. Basically, the law that is no law. So there is no law. So if I punch a man in self-defense, well, I have every right to do because there's no law stopping me from defending myself. It's the law of necessity. It's to establish the underlying debt to the bankers and create legal entities. The legal entities are subject to the jurisdiction in which they were created to exist. and created the jurisdiction itself correctly. The so-called fraudulent and unratified 14th Amendment was proclaimed to be passed in 1868. This was a cestui trust operated in the laws, incorporated in a military, private, international, commercial, de facto, jurisdictional, created by the and belonging to money power existing within the emergencies of the War Power Act. The only operational jurisdiction since the dissolution of Congress in 1861 through the 14th Amendment, an artificial person, corporation, entity, franchise existed, citizens of the United States, and was born into a private, corporate, limited liability. Section 4, citizens of the United States were born, remember, that's section, the 14th Amendment, Section 4, the validity of the debt, public debt of the United States and the bankers shall not be questioned. Within the above reference of jurisdiction, the international bankers and private foreign-owned Congress formed a commercial agency government for the District of Columbia on February 21st, 1871, Chapter 62, 16, Stat 49. This is a corporation that was recognized in 1878. Chapter 180, 20th Stat 102, and renamed United States Government. This corporation is privately trademarked and named as the United States, U.S., U.S. dot, that's U.S. dot, U.S. dot, comma, and then U.S. It's just U and then S, and then USA with no dots, and America. When the United States declared itself a municipal corporation, it created what's known as a cestui trust under the implementations of the Federal Constitution of 1871 and incorporated the United States Constitution of 1787 and 1791 was amended by law. Naturally, the trustees of the trust, it's empowered the United States government to change the terms as will as evidence. The federal government of the Constitution in 1871, the 14th Amendment, the people of the United States, without the consent, were declared citizens and granted civil rights. And these so-called civil rights are nothing more mere than privileges. Privileges are licensed regulations and reinterpreted and suited the purpose for the reason. The federal corporation government conveniently somehow forgot to disclose to the people the term citizens, which may have every living, breathing inhabitant subject and defined in the law a vessel. Now remember, vessel is defined in the 80th Congress Session 2, 645, June 25th, 1948. Again, watch, read, educate yourself. 1912, bankers owned a bond. We're keeping the U.S. afloat due to the bankers' refuse to refinance the financial debt. This resulted in global martial law, creating martial law ruled Congress and compelled the Federal Reserve Act of 1913. This act surrendered constitutional authority to create, control, and manage an entire supplemental of the United States to a handful of privately, mostly foreign-owned. Most people like to say it's Israel, but it's not Israel. It's Israel, it's Britain, it's Austria, it's Germany, it's the United States, it's many different corporations. And this was done through 1914 to 1916. They began circulating the Federal Reserve notes, the money along the nation's reserve currency, which was the gold and silver at that time. Because remember, we're at 1916, we haven't hit 1933 yet. And these amounts for the bill was yet to be paid for what it owed for the new benefits and be able to carry. The paid interest of the Federal Reserve Corporation in gold, the U.S. Treasury became progressively depleted in gold. America's certificate, coins, and bullion were continually shipped off in coffers to various European banks and power elites. In 1933, the treasury was drained and the debt was larger than ever, traditionally known as insolvency. Insolvency is when you owe more money than you're actually worth. That's when President Roosevelt declared bankruptcy, and that we became property under the Senate Document 43 of the 73rd Congress First Session. We were property and owned. Review of countless Supreme Courts. You can see Erie versus Railroad and Thompson, 304 U.S. 64-2, which established the state has constitutional rights, not the people. The people have been pledged to bankruptcy in 1933. The federal law administered in the United States is a private commercial law of creditors that is due to bankruptcy. Every citizen of the United States is pledged, and an asset is supported. Bankruptcy must support the insurance premiums on the underwriting necessary, the bankrupt government, and the operations under Chapters 2 of bankruptcy reorganization. And upon declaring that the operation function through only corporate colored state, all capital letter names, has no access to the sovereignty, substance, or rights in standing to law. The Supreme Court has held that the general universe common law no longer accessible in operation to the federal courts based on 1933 bankruptcy. And give me a second, I'm going to pause again. So remember that all commerce will be regulated through contract through British attorneys only, known as esquires. The condition of concession still exists today. No attorneys or lawyers in the United States of America have ever been licensed to practice law. They are exempt themselves, and therefore a fiction person, and only admitted bar members. The practice of private franchise is called Private Franchise Club, called the Bar, is an acronym for the British Barrister Accredited Registry. What a mouthful. Article 1, Section 9. No clause, no nobility shall ever be granted in the United States, and no person shall hold an office of public trust or any sort of elopement, office, or title whatsoever from king, foreign, prince, or state. Well, right there, they're obviously doing that. And you have to remember, what is a judge calling themselves? Honor. Your honor. Well, if I'm calling you your honor, well, that's a title's nobility. The high lords were called honors or lords. All courts are operated in non-constitutional, non-Article 3 legislative tribunals. All courts are under Title 11 bankruptcy court. These courts are statutes in reality, commercial obligations being applied for the benefit and privilege and of discharge of the limited liability of the Federal Reserve monopoly. Money of the Federal Reserve notes are debt instruments only. Again, I'm going to pause this so I can get to my spot here again. I want to read more, so give me a second. I want to read USC 3-419, instrument signed for a common accommodation. If an instrument is issued for the value of the benefit of an instrument of a common party, another instrument and another party to an instrument, another party to the instrument accommodating party, signing the instrument for the purpose of incurring liability on the instrument without being directly the beneficiary of the value given for the instrument is signed by the accommodating party for the accommodated. So remember, if you sign that, you become the debtor when they're actually the debtor. An accommodating party can The accommodating party may sign the instrument as the maker, the drawer, the acceptor, the endorser, and the subject to subsection D, and is obligated to pay the instrument in the capacity for which the accommodating party signs. The obligation of the accommodating party is enforced, notwithstanding by any statutes of fraud or whether the accommodating party receives any consideration for the accommodation. The obligation, subsection D, the obligation is of the instrument in the capacity in which the accommodation signs. You are signing as a debtor. You are not signing as the beneficiary. Sign your name. Not all capitals. How you usually sign it, one capital, lowercase, one capital, lowercase. You sign it underneath beneficiary, equitable title holder, and all rights reserved under 207, 307, and under UCC 3-14. Now, subsection D says, if the signature of the party of the instrument is accommodated by the and unambiguously that the party is guaranteed to collect rather than the payment of obligation to another party. To the instrument, the signer is obligated to pay the amount due on the instrument to the person entitled to enforce the instrument, only if the execution of the judgment against the party is returned unsatisfied. 2. The party is insolvent or insolvency proceedings. 3. The other party cannot be served with the process. Or 4. It otherwise has been apparent that the payment cannot be obtained from the other party. The accommodating party who pays the instrument is entitled to reimbursement for the accommodation and is entitled to enforce the instrument against the accommodating party, and that's what they're doing. They're enforcing an instrument on you as the accommodating party because you have not rebutted statements and not taken your position as the individual who is the beneficiary, equitable title holder of the estate. I would like to read Uniform Commercial Code 10-104. This article on documents Title 7, Article 7 does not repeal, modify, prescribing the forms of content of the title or services of facility appointed to the bailee. Remember, we are the bailer, the bailee, we are the creditor. Business in respect to specifically dealt with within here. Otherwise complies with the definitions of title sections 101-201 amended. B. The as used resolution. The term obligation means the obligation including every obligation of the United States. Remember, that's defined under the 80th Congress, Session 2, 645, June 25th, 1948. The term coin and currency means every coin or currency of the United States, including Federal Reserve notes and circulating notes of the Federal Reserve. The National Banking Associations. Are you willing to commit a crime to the PA of an alleged debt? So I'm going to explain some commercial crimes, some forms of commercial crimes that are federal and state under the 27 CFR 72.11. Any following crimes, federal or state offenses are against revenue laws: burglary, counterfeit, forgery, kidnapping, robbery, illegal sales or possession of deadly weapon, prostitution, including soliciting, procuring, pandering, white slave keeping, keeping house of ill fame or like offenses, extortion, swindling, conference games, acceptance to commit, conspiracy to commit, compounding any of the foregoing crimes, addiction to narcotics, use of marijuana. These are all considered financial, commercial crimes. And Article 1, Section 10, Article 11, and Section 1, and the U.S. Banking Code. Any action, complaint, and transaction initiated in state, federal agents are commercial crimes in nature of the light that the fact that they impose a quasi-monetary fine in violation of Article 1, Section 10, Article 11, Section 1, and the U.S. banking industry. So let's look up Amendment 14, Section 1. All persons born and naturalized in the United States are subject to the jurisdiction thereof and are citizens of the United States. And when they reside, no state shall make and enforce any laws which shall abridge the privileges citizens of the United States, nor shall deprive any person of life, liberty, property without due process, or deny a person its jurisdiction without equal protection of the law. Now, let's look at the term United States. I'm referring to Title 28, subsection 3002, Part 15A, which means United States means federal corporations. By the citizens of Washington, D.C., interchangeably, the United States of Washington, D.C., Incorporated became a business of the United States on February 21st, 1871. Via the last page of the 14-page document, when at the same time the corporation was declaring themselves to be the owner and successor of all corporations, all properties, of all said properties and corporations, and everything and all your stuff. Notice that the crimes under federal regulations 27-712.11, whether state or federal or commercial crimes, every one of them because of the corporate person within the meaning of the 14th Amendment. So you are considered an entity till you claim your straw man. Many people have argued that the United States is not lawful. The 14th Amendment, I mean. The 14th Amendment is not lawful. Of course, Congress knows it's fraud. March 8th, 1957, Memorial to Congress, 14th and 15th Amendment to the United States Constitution were declared void. Every member of the Congress got a copy of November 26, 2008 CRS report for Congress, 5 of which the CSR two top paragraphs, 12, which made it clear executive orders 6 ordered the 14th Amendment ratified. Executive Order 7 ordered the 14th Amendment lawfully and published. Now, where's the written letter of the Constitution lawfully to ratify the amendment of the Constitution with the executive order? These two are not even executive orders. What they were presidential proclamations, Presidential Proclamation 11 and Presidential Proclamation 13. These were actually created they created 2 fake executive orders that were booked and paged as proclamations. Andrew Jackson, the president of the 14th Amendment, stated that it was a de facto government which did it. The de facto meaning one that maintains itself in the display of force against the will and rights of legal government, and is successful, at least temporarily, in overturning the institution of the rightful legal government by setting its own laws in lieu thereof. Wortham versus Walker, 133 Texas 255, 128 SW 2D 1131145. Again, the United States have created a corporate its own private government. 14th Amendment. Liability, subordinates, interference, obedience towards government, or to be effected provided that the provided answer for the again, the 14th Amendment created different governments. The citizen, a different jurisdiction as found in the Constitution. Corporate authorities, we've covered that. It states that subject and liable to the subversion, inferior obedience to the governed or affected by the provided answerable or, and then there's a case here, it doesn't, liable, subordinate, subservient, inferior, obedient to, governed or affected by, provided answerable for, or, and that's American MFG CO V Commonwealth 251 Mass 329 146 Northeast NE NE Hannibal Trust versus Elise 31 MA 485286 SW 371377 Allen versus Simon 97 West Virginia 38 125 Middleton versus Finya 25 California 76 Manning versus Sam's 143 Georgia 205 84 East BL Holman versus the employer of reinsurance and companies 45th Congress, 6th session, 3rd session, 62, chapter 62, 63, 64, 65, 1987, hereby declared the successor of all corporations and all property said corporations of the County of Washington shall be vested in said District of Columbia. So, Section 4 makes you therefore responsible, and you have no right to question any validity that they tell you. The Constitution was bifurcated. Bifurcated is defined as separated. We'll call it bifurcated because it's separated from the original jurisdiction of the outlined Articles of Confederation. Article 1, Section 8, Clauses 16, 17 clearly set this out. This is important to remember, as this is going to be a particular in our lessons that we're teaching. So after the bifurcation, the United States created a social contract structuring government that was established on a much higher plane than the preliminary system of the United States of America. The social compact is also known as the constitutional republic, in which certain powers are delegated to the state, the corporation, and franchised by the New World Order of the social compact, which is the banking industries. A certain amount was delegated to the agencies, federal agencies, residual power reserved in the powers of the signatory parties, which is respectfully the parties of interest. We, the people of the United States, which we are not the people of the United States, either signed the Declaration of Independence, who neither signed the Declaration of Independence nor the Articles of Confederation. The Constitution of the United States is for the United States of America, or who related to the members of posterity of the people and the signatures thereof under the new social compact. We, the people of the United States, under the new social compact, representative, we, the people of the United States, by the way, agency representing, remember the term agency, representing the United States, assembled, enumerated powers delegated by the social compact known as the Constitution of the United States. The term bank, defined in Black Law's Dictionary, refers to lawyers, judges. This is Black Law's Dictionary, 4th edition, and particularly Waters Maritime. I recommend also reading the full term of bank defined in Black Law's Dictionary 4, but some of it also includes judges and lawyers. I've also discussed in other videos that lawyers, judges, they have to pay taxes, they have to go to the courts. If they don't, then they're dishonoring the creditor, you. The 1781 that chartered the First National Bank for a term of 20 years. The European bankers were holding the debts before the war. The loans were worthless, unbacked, non-secured, printed money. These charters were only for the bankers. And because of the bureaucratization at any given point in time and period, under the jurisdiction of the private bureaucrated government of the assumed 10-mile squares of Washington, D.C., were the governments and employees who created the social compact. They reside as residents and non-aliens within the territories owned by the United States, formerly slaves. The former citizens lived in the southern parts of the social contract, known as the United States, for the United States of America. Captured became 14th Amendment citizens by martial law, and by the 15th Amendment. The remaining compact of people, prosperity related to, could still invoke the power of the government, original jurisdiction on the Republic side of the Constitution, only limited by the application and curtail privileges immunity effected pursuant to the way of the Act of July 27, 1868, C-249, 1, 15, Stat. 23, Rev. Period, Stat. Period, 1999, now Title 8 U.S.C. 800 and 801, also known as the Expedition Act, also known as the Act that's at large. The new democracy, which started to created the mob-ruled martial law. In 1871, again, bankruptcy loomed. 10 square miles, the new military construct, known as the old familiar known construct of the agency of the United States. Congress assembled, which the Constitution by the laws, not authorities under the Constitution, but the authority over the Constitution. They copyrighted not only the Constitution, remember they took it from the Moroccan people, but also many names of the United States, such as U.S., the United States of America, U.S., and many other titles of intellectual property and secured copyrights. The U.S. Has beneficiaries and original signatures of the Social Compact. You have to look up at the Virginia Charter of 1601. The state bar has a charter in 1913, an international charter that gives them power here in the United States. Again, you have to remember that they're foreign agents. I was doing research, and we must remember that the politicians and the posterity of the original signature members are only under the compact. And there's an illustrated universal history in 1871. If you look in the Illustrated Universal History of 1878, page 504, it tells us that the southern states were swarmed with British agents. Because remember, they didn't leave until 1795. They didn't leave until later, but I guess there were still agents there. And so the compact known as the compact state known as the Southern Carolinas on December 29th, 1860, within the weeks, the people and the beneficiaries prospered from the signatures of the Social Compact, and the 6 states joined in the conspiracy along known as the Confederate States with Jefferson. As I was stating, you have to remember that it's for posterity only. Signature members are under the compact only. The United States Constitution is assuming 10 square miles. You have to remember that during the Civil War, during Abraham Lincoln, the Social Compact, we were being funded by both. Remember, in 1795, we didn't have agents leave until 1795. And the illustrated history University History in 1878, page 504, states that the southern states were swarmed with British agents who conspired with local politicians to work in the best interest of the social compact known as the United States. This was shown with propaganda, and an open rebellion resulted in secession of the compact state known as Southern Carolina on December 29, 1860. Within weeks, the beneficiary prosperity of the original signatory of the social compact of the 6 states joined the conspiracy, and they joined in with the Confederate and became known as the Social Compact of the Confederate Americas, with Jefferson Davis as president. Now, shortly thereafter, in March 4th, 1862, Lincoln ordered a blockade of all the southern ports pouring in from Europe. The official date started the Civil War was given 1861 when Fort Summers in South Carolina was bombarded, but it was obviously that it began much earlier than that. In 1861, the European troops, British, French, Spanish, poured into Mexico in defiance of the Monroe Doctrine. This was a widespread European aid to the Confederacy, strongly indicating that the Crown was preparing to enter the war and look for the North, and the future of the Union was bleak indeed. Remember, he funded both sides, so he could, whoever he wanted to win. Abraham Lincoln actually went to the Crown, the perennial enemy of the United States, and the envelope that he sent to Caesar Alexander II postulated, it had been postulated that he weighed the unopened in his hand, and before he even opened the known of the contents, we granted any request it may contain. Unannounced, the fleet Limbisky steamed into the harbor on September 24, 1863. The Russian Pacific Fleet, Admiral Popovich, emerald San Francisco October 12th. Of the Russian act, Gideon Wells said they have arrived to tide the Confederate, and they arrived at high tide of the Confederacy and at low tide of the North, because England and France hesitate enough to turn the tide for the North Empire of the city, page 90. History can be found throughout this one-mad act that Lincoln had done and agreed. He was later killed. You have to remember, he was later killed, and the reason he was later killed is because he was trying to change the banking industry through the Greenbacks Initiative. Because remember, we haven't gone bankruptcy yet because we're still in the 1800s, but due to the fact that Abraham Lincoln signed an agreement, the Virginia Charter of 1601, along with other agreements, he had turned us now into debtors at the will of the British government. You have to remember that the British is also owned by the Vatican, and the Vatican owns and claims that they claim everything. Remember, this federal corporation under the Title 28, Section 3025, Section A, and then Title Sections 3025, Chapters 176. The United States is a corporation, 534 Federal Supplemental. And from 1776 to 1789, the United States Confederacy, and after 1789, was a single individual corporation, a federal national system. And you have to remember that the Constitution only has it's copyrighted, that we have no rights to the Constitution. The Bill of Rights left at this point in 2009 4 amendments, 13th, 14th, and 15th and 16th. These courts required to take cognizance of any people appearing in court except those operating in international public order by the way of supreme law of the land, treaty, within the frameworks of the social compact, Okamura versus an Anderson. That's KIYOKURA versus ACHESON 99 Federal Supplemental 5887 D of Hawaii 1951. You have to remember that there is no public courts, that the Congress in 1766, the Senate Bill 94-201 and 94-381. From this point forward, the officers of the courts can construe the laws to mean anything that they choose them to mean. See Dinette versus Turner, 439 PRPTS 266 1968, and Utah versus Phillips and Republica versus Swears. So now you have an illegal entity acting in the capacity for you in the fact of a corporate United States upon an agreement of a social compact. But how did this social compact come to be? First, you can find the Senate Bill 94-201 and 94-381, where I stated that they could do this on page 25 of that document.
Give a little bit of time to do what it needed to do, get that down that road. Yeah. Well, yeah, it was, so that's what I was saying.
I want to continue I didn't even realize I was playing. I want to continue to show you the Senate Report 93549, 93rd Congress, first session, summarizes the situation best as possible regarding the shadow government. A majority of the people of the United States have lived their life under the emergency rule, and the United States action has taken by the government in times of crisis, remember, at least the Civil War, in important ways shaped the phenomenon of the permanent state of national emergency. So they acknowledge that we are under national emergency, and they acknowledge and understand the Organic Act District of Columbia and Dinette versus Turner 1868, which argues this. The Pacific Reporters 266, 267 in Utah to Phillips. The corporation is known as the United States, hence the new military structure known as the Social Compact of the several unions, which remains formerly the Republic and formerly the social impact under the rule of the bankers solely for the express and benefit. Only for banking industries. When you sign up for these benefits, you are signing up and becoming a corporate slave and becoming into corporate ownership. When you become and you want to become a United States citizen, what you are doing is joining a corporate state. There are two governments and two flags. Look at Reporter, second series, volume 540, page 941, 942, 1975. However, the most important fact about this amendment is the new class of citizens, that it did not have any effect on the sovereign. people, but both classes still existed when the Constitution was adopted. So the sovereign people does exist. They acknowledge that the sovereign man does exist. You just need the information and needed to know what the information was, and this is why I'm making this video today. The United States Code in total was put together by the District of Columbia, copyrighted private international law, and is applicable to the District of Columbia and any jurisdiction in the preview of its military dictatorship. Their own rules of jurisdiction in the United States attorneys have no business prosecuting outside the District of Columbia or any federal territories. The military construct of district courts have no venue outside the District of Columbia, and therefore no jurisdiction outside the District of Columbia or its possessions. The military Congress cannot pass laws applicable in several states of the Republic than otherwise outside of the presumption of emergency operating under the laws of necessity created by the Congressional Sindai. That's SINEDIE. If all laws in the District of Columbia are private and international laws, including all laws of the United States and statutes and revised statutes passed after 1871. Remember that groups like the FBI, CIA, and DEA are not part of the United States. None of these were ever entities of the United States. The adoption of all the uniform universal codes by all entities allowed them to designate copyright name of every state since 1964, along with all other acts incorporated. The military structure and multi-jurisdictional franchise venues, military social compact, social construct known as the United States, made the Universal Commercial Codes the supreme law of the land ascertaining to the secured transactions and even documents of title through UCCA, speaking hidden terms considering document titles. If you are privately agreeing with three other people like the county, the judge, the clerk, the president, playing Monopoly, you of course have to use Monopoly money to pick out a little avatar like a shoe or a race car, right? If we dig a little deeper, we'll see modification to the public law in a different matter. The laws, for instance, pertaining actual to the statute at law book. This is identified as a Chapter 48 Stat 112. It contains the very same words as HJR 192 through one resolution as one of its public laws. We should refer to the federal government's obligations in Chapter 48 Stat 112, not HJR 192. The federal government is looking away, took away our ability to pay the debt with lawful constitutional money. This doesn't make us subject to to Congress or the federal government, and thus the resolution does not apply to us. However, the obligations to us under the public law does apply, as there is still this day efficiently lawfully money to guarantee the circular to meet the needs of the people, including us. If you look at the FRCP Rule 2, all actions are civil, period. This applies to all contracts, private obligations, agreements, extra-constitutional, and various laws because the Constitution gives you unlimited rights to contract in commerce. Again, look up the contract clause of the United States Constitution. You are in an equity, ladies. Equity jurisdiction is the jurisdiction to compel any contract to perform. To contract you to any party is based on a fair particular situations. The term denotes the spirits of fairness, justice, and right to deal with the regulation intercourse of men to men, connecting to agreements and obligations performing accordingly to the government who are signatories, otherwise such acquisitions among them until the such substance may arise